The Ebonyi State Governorship Election Petition Tribunal, sitting in Abuja, on Friday reserved its judgment on petitions seeking to nullify the outcome of the gubernatorial poll held in the state on March 18, 2023. The petitions were brought before the tribunal by the People's Democratic Party, PDP, and its candidate, Chief Ifeanyi Odi, as well as by the All Progressives Grand Alliance, APGA, and its candidate, Professor Bernard Odo. The petitioners are praying the court to void the declaration of Governor Francis Nwifuru of the All Progressives Congress, APC, as the winner of the gubernatorial contest. Justice A.I. Ogumoye led a three-member panel adjourned to deliver judgment on the petitions after all the parties, through their team of lawyers, adopted their final briefs of argument. While adopting their process, PDP and its candidate, Odi, through their team of lawyers led by Chief Chris Uche SAN, maintained that Governor Nwifuru did not secure the majority of lawful votes cast during the election. The petitioners told the tribunal that Nwifuru's election victory was characterized by corrupt practices, alleging substantial non-compliance with provisions of the Electoral Act 2022. Besides, they argued that Nwifuru did not validly resign from the PDP before being nominated as the APC's governorship candidate.
And one thing that is very, very fundamental is that they claimed that the man, Nwifuru, that he resigned from PDP. And they tendered a document which they called the letter of resignation, which was admitted in evidence. But now, you can see, as we demonstrated, that letter of resignation, which was completely an afterthought, was not signed. And you know that an unsigned document is a worthless piece of paper.
According to the petitioners, Nwifuru, being a PDP member at all material times before the governorship poll, was not eligible under Section 177C of the 1999 Constitution as amended to have been sponsored by the APC to contest as its flag bearer. They told the tribunal that before the governorship contest, Nwifuru, elected into the Ebonyi State House of Assembly, served as Speaker while on the ticket of the PDP until May 2023. Consequently, PDP and its candidate in their joint petition prayed the tribunal to declare that they were the valid winners of the governorship election. They prayed the court to withdraw the certificate of return issued to Governor Nwifuru by the Independent National Electoral Commission, INEC. The petitioners also cited a subsisting judgment of a high court in Ebonyi State, delivered by Justice Henry Njoku, which they said held that Nwifuru and other lawmakers in the state that purportedly defected to the APC were still members of the PDP.
He assumed the office of Speaker of House of Assembly on the platform and ticket of PDP. Then if he claimed that he had left PDP, he should have left PDP's property, because the basis upon which he got into the House was on that platform. So, but he still retained the seat, contested the election when he was not sponsored by PDP. And that runs against the provision of Section 177(3) of the Constitution, which has been put in place along with Section 109, preventing such cross-carpeting, in order to checkmate political prostitution, which has done so much to destroy the development of our constitutional democracy in this country. So that is why this case is very, very important, and that's why we had to make all these points before the court. Yes.
On their part, APGA and its candidate, Odo, prayed the tribunal to nullify the election and order a fresh one. While adopting their final written address, the petitioners, through their team of lawyers led by Jibrin Okutepa, SAN, argued that Governor Nwifuru was not qualified to contest the gubernatorial poll, insisting that he did not validly resign his PDP membership. The petitioners averred that a second respondent was until and after the election a member of the Ebonyi State House of Assembly and also occupied the office of the Speaker of the said House under the platform of the People's Democratic Party, PDP. He was not qualified to contest the election to the seat of Governor of Ebonyi State conducted by the first respondent on the 18th of March 2023 wherein the second respondent was wrongfully returned elected. Firstly, it is a settled position of law and firmly rooted in the Constitution of the Federal Republic of Nigeria that a person aspiring to contest the election for the office of governor in a Nigerian state must fulfill the dual prerequisites of political party membership and sponsorship. This provision is unequivocally captured in Section 177C of the 1999 Constitution of the Federal Republic of Nigeria as amended, where it is provided as follows. A person shall be qualified for the election to the office of governor of a state if c. he is a member of a political party and is sponsored by that political party. On the whole, it is submitted that the petitioners have made out a case for the relief seeking the order of the Honorable Tribunal for a fresh election, excluding the second respondent, whom a valid claim has been made out for his disqualification. The relief for a fresh election is predicated on the fact that upon the disqualification of the second respondent, none of the remaining candidates would have satisfied the constitutional requirement of being declared governor of Ebonyi State, having regard to the results declared in Exhibit P1 and P8, Section 179, Subsection 2 of the 1999 Constitution as amended.
The petitioner's case is that the second respondent who was returned by the first respondent, INEC, was not qualified to have contested the election at the time he did. And the reason which we have advanced, which was not in fact denied by the other side, is that the second respondent who was elected into the Ebonyi State House of Assembly in 2019 on the platform of the People's Democratic Party, and from where he became the speaker, never resigned his position as a member or speaker of the Ebonyi State House of Assembly throughout the period between 2019, when he assumed that position, to 2023, when he was sworn in. And having been elected into that house on the platform of the People's Democratic Party, it was impossible for him to have been sponsored by the All Progressive Congress without first resigning and vacating his office. If, on the other hand, he is purported to have resigned, then he ought to have vacated his seat. He never did. So for all intents and purposes, he remained a member of the PDP. And to that extent, he could not have been sponsored by the APC. This is the summary of our case. And his non-living of the Ebonyi State House of Assembly as a member was never denied, either in their pleadings or in evidence before the Honorable Tribunal.
Thank you very much. Say your name to the camera.
John Matthew is my name.
Meanwhile, Governor Nwifuru, through his team of lawyers led by Dr. Onyechi Ikpeazu, SAN, urged the tribunal to dismiss all the petitions. He insisted that he was validly elected, adding that a judgment that declared him as a member of the PDP had since been voided. Governor Nwifuru argued that he duly resigned from the PDP and joined the APC in compliance with the provisions of the law.
My name is Ato Biokafu. I'm a senior advocate of Nigeria.
Thank you very much. We are more or less at the last lap of this petition. So how optimistic are you awaiting for judgment?
Let's suppose look at the camera.
As counsel who has been in the matter, we are optimistic because this matter for us is not that complicated. It just rests on the issue of qualification. They are saying that the governor was not qualified at the time he stood for the election. And that's just the simple issue before the court. We raised issues of whether the court had jurisdiction or not to even entertain what they are saying. So we expect that judgment will come and justice will be served.
Likewise, the APC, through its lawyer, A.A. Ibrahim SAN, urged the tribunal to dismiss the petitions for want of merit, adding that the petitioners failed to prove their case beyond reasonable doubt.
As lawyer to APC, the APC produced the present governor. He was a member and he was sponsored by him. We are saying that it does not lie in the amount to tell us who is our member. We are and that if he was a speaker and never vacated his position as speaker, he was elected by his colleagues, not elected because he was a PDP member. So that is our simple position. And they said it is the receipt was forged. Who forged the receipt? They can't tell us that our own membership cards are not forged. So that is our simple position.
After it had listened to all the arguments, the tribunal said it will communicate the date for judgment to the parties.